This is the young lady that a few days ago you took into custody because she picked up a new case while she was out on our bond.
Right, okay.
She had the felony case. The felony's reset. She's here for her, I guess, arraignment on the new bond. But I think you had already modified her bond conditions 2 days ago. So.
Welcome back to another intense courtroom breakdown. Today's cases are absolutely wild. We've got a woman who keeps driving without a license while already on bond for a felony, a theft case that's been dragging on for over 3.5 years, a DWI defendant who's about to make a decision that'll follow him forever, and a group of young men caught in a stolen vehicle that crossed state lines from Louisiana to Texas, with one of them having a gun. The judge is not holding back, and some of these defendants are about to learn the hard way that the legal system doesn't play games. Buckle up, because this one is packed with drama, tough love, and some seriously questionable life choices. Let's dive in.
Miss Loyola.
We do need to talk about some driving issues, though, Judge. So
She doesn't have a license. That's the issue. If I remember correctly, right?
I think you do have a license.
I was working on getting it fixed. It was not an
You don't have a license and liability insurance in your name. Don't drive. It's as easy as that. If you get your license, then we can talk. But until that point, I don't care what you have to do. I don't care what baby needs picking up. I don't care. You cannot justify getting into a car and driving unless you have a Texas driver's license and liability insurance in your name.
That was working on getting it.
Okay, working on it doesn't mean that you get to drive because you're working on it. No driving until you have a license in your possession. If I find that you do, I can have a contempt hearing, and every time you drive hereforth, it's up to 6 months in jail and a $500 fine. If you pick up a fourth case, I'm going to lose it. Do you understand?
Okay, let's break this down because the judge is not playing around here. This is classic courtroom escalation. She's already on bond for a felony. She picked up a new case, and now she's driving without a license or insurance. What some people don't realize is that driving violations might seem minor, but when you're already in the system, they stack fast. Every single time she gets behind that wheel without a license, she's risking 6 months in jail and a $500 fine for contempt. And the judge just said if she picks up a fourth case, he's going to lose it. That's judicial language for, you're going straight to jail, no questions asked. Here's my question for you. Do you think driving violations should be treated this seriously when someone is already on bond? Or is the system being too harsh? Drop your thoughts in the comments below.
Asking you to do is follow the law. I'm not asking you to do Pythagorean's theorem. Okay, we'll give you a normal setting. Well, actually, no, we won't. The assault's at nearly 200 days now. Is this your case, Sebastian?
Yes, it is.
Discovery complete?
I believe it is, Judge. I'm trusting.
Judge, the problem is it's the same transaction out of the felony case. So I've tried to reach out to her felony attorneys. She tells me that it's bad communication with that particular person. So I'll have to try really hard to find out because she's hoping
Right here.
Yes.
Mr. Gould, Mr. Gold was here. That's the lawyer.
Yeah, I saw him today.
Did you speak to him? And does he know the?
Yeah.
Okay, so I guess he knows the situation.
I tell you right now, Judge, as far as the assault, the only thing is that there's some CPS records. I still don't know if the case is closed because obviously they don't give it to us until the case is closed. But apart from that,
Does that really come in this case anyways?
It can. So typically the things that would be in there is typically they do an interview with the defendant, they do an interview with the kids.
Unless it's relevant, I don't know, but.
Yeah. But you are right. It is a case by case basis.
Can you tell me when that felony is reset to?
The felony is reset to the 21st.
Is there an offer in the felony case?
I believe the note is. Essentially the offer upstairs is that if she takes something on the misdemeanor, then we'll get rid of the felony.
Okay, so they're set for 4/21. I'll give you the same day after the day it's clear trial here.
Gotcha. 421, Judge?
21. Right.
Is there any
I would
way
imagine
we-
that's probably a global offer for everything.
Can we go 422?
Sure.
Okay. That's
But then she'd be coming that day and then the next day. She's on bond.
right. I got you.
It's up to you.
But hopefully I'll talk to her. If we can get the deal together, then I might just bring her back before then to get it done. Like
Okay,
I
but
normally
after
do.
that setting goes clear trial.
I got you.
Got it. All right, John.
Thank you, Judge.
Leaves you are charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Has probable cause has already been found on this, right?
Yes, Your Honor. So it's already been found, but this case is really old. She didn't come to court. So this time she got rearrested for the same charge.
Okay. Where's this from? If you don't mind.
Your Honor, I'm sorry,
Just needs.
Eves?
Need, N,
Yeah, thank you.
N-I-E.
Your Honor, the offense date was October 11th, 2023.
Where from though? With that.
Oh, where? I apologize.
Walmart.
It was Walmart, Your Honor.
Okay, can you look to see if discovery is complete?
Yes, Your Honor. It does look to be complete, although we'd have to talk about the videos. Yes.
Well, just to get this case, because they already had a prior PTI offer, which you're supposed to do an anti-theft course. They just reinstated the offers. They said that they'll still take the offer.
They said that they're going to keep the offer?
I spoke to them this morning.
Okay.
So she's going to complete this class this week, and I'm going to send it to them for dismissal.
Okay, this case is 1,269 days old. I'm now putting a monitor on your ankle so I know where you are at all times. You have 2 weeks to get this class done. If you don't, I'm going to set your case for trial. Do you understand? You get no more resets after that.
Okay.
Okay, all right.
Thank you, Your Honor.
So Felicia, if she can get today, please.
Did you catch that? 1,269 days. That's nearly 3.5 years this theft case has been sitting in the system, all because she didn't show up to court. This is what happens when you ignore your legal obligations. Folks, she had a PTI offer. That's a pretrial intervention, which basically means take an anti-theft class and the case gets dismissed. No conviction, no record. But instead of handling it, she goes to the court, got rearrested, and now the judge is slapping an ankle monitor on her and giving her just 2 weeks to complete that class. If she doesn't, straight to trial. This is a legal system saying we're done playing games. The lesson here, when the court gives you an easy out, take it. Don't let a simple shoplifting case turn into years of legal drama.
You are Mr. Vasquez Lechado.
Yes.
Sir, you're charged with driving while intoxicated, facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 21 days in jail with credit for the 7 days that you have done. You're pleading guilty to this offense and it is now going on your record. You need to understand that from now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. If you ever get pulled over from now on, officers will look at your record, they'll see a prior DWI. If they smell alcohol or dope on you, it's probably not going to go well. So from now on, I would never, even if you have a sip of alcohol, don't get into a car and drive. It's probably not going to go well for you. You're giving up a lot of rights by entering into this agreement. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen or a possible immigration consequence, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it goes on your record. It'll be there forever. Is this what you want to do? You plead to the offense guilty or not guilty?
Guilty?
I'm going to find you guilty. I will follow the agreement, send you to it. I'm now going to suspend your ability to get a driver's license for 90 days. Do not drive until you get a license. And good luck to you, sir. Thank you, Mr. Martin.
And Your Honor, if I may mention, I did want to mention something else, Your Honor. This was a case that I was appointed to maybe like 2 days ago. I did speak to Mr. Vasquez to let him know that's not all the evidence is in, and that he does have the right to that. He has been in custody since January, he got transferred to ICE, which he says he no longer.
So-
wants to wait for the evidence.
You need to understand that not all the evidence is in this case. By getting all the evidence, it's very possible that she may have a chance to fight your case and beat it. Once you plead guilty, there's no turning around. You cannot come back and return this like you don't like it from Target. Do you understand? Do you want more time to fight the case, or do you want to continue with this plea?
¿Quieres seguir con esta declaración? I'm fine like this.
Okay.
¿Está
All
bien?
right, I'll make a documentation that
Thank you, Your Honor. I appreciate that.
Documentación de ahí.
it's against your...
Yes, Your Honor.
This right here is one of the most critical moments we see in courtrooms across America, and most people completely miss what just happened. The defense attorney literally told his client, "We don't have all the evidence yet. You might be able to beat this case. Once you plead guilty, you can't return it like something you don't like from Target." And what did the defendant say? "I'm fine like this." He chose to plead guilty anyway. Here's what's really going on. He's been sitting in custody since January. That's months behind bars waiting for a trial. Many defendants plead guilty not because they're guilty, but because they're tired. They want out. They want their life back. This is the harsh reality of the justice system that most people don't see. The attorney even put on the record that this was against his advice. Would you have waited longer to fight the case, or taken the deal just to get out? Let me know in the comments.
All right, come on up.
How you doing? Hey, Judge, good morning. This is Mr. Dalen Calhoun, Judge.
I'll sign this real quick.
Don't say anything about the case, okay?
All right.
Use the focus of getting to the proper place to handle your business.
Who?
That's right. That's right. I was so confused.
Scott Sanders?
Okay, what is his name?
His name is Jalen Calhoun.
Good morning, Mr. Calhoun.
Good morning, how you doing?
So it seems that you are one of 4 co-defendants that we have on a case arising out of another state.
Yes, sir.
You are wanted out of,
Louisiana, Natchitoches Parish. I butchered the pronunciation, but
Natchitoches.
Natchitoches.
What is it?
Natchitoches.
That.
Louisiana.
Lawyer is asking me to set you a bond, but I don't know. I don't know you. I've never met you before, and I have a very short amount of time to get to know you to see what kind of person you are.
Right.
Paper really tells me who you are. The words coming out of your mouth, I just right. So, tell us about Mr. Calhoun.
Your Honor, he's wanted out of Louisiana for transfer and possession of stolen vehicles, not equivalent to theft of a motor vehicle, and him and 3 other individuals, one whom is charged with UUMV, were found same day where they stole a vehicle. We have a parallel charge with Louisiana where they're charging him for the theft, and we have for the UUMV for the driver.
But the thing about it is, I wasn't there.
Do you really think that you can just start spitting out something? Where do you think you are? Really?
My bad.
You think that this is helping you, Mr. Calhoun?
Sir.
You're not at home. You're not on the street. Okay. Please.
Your Honor, the same day that they stole the vehicle, which was captured on surveillance off campus, they traversed state lines and came to Texas, and they were found in Harris County with obviously traffic infraction being the probable cause, and found with all 4 occupants of the vehicle. The fact that they traversed state lines, the state would be opposed to a bond. There was also, and because that's a charge, I know before the office reports out, is that there was also a firearm found on one of the passengers and that they were trying to conceal. At the time, the officers were getting everybody removed from the vehicle, and obviously 2 of them being under the age of 21. So they would be opposed to a bond for.
So, hold on a second.
Yes, Judge.
It's a stolen car.
Yes, Judge.
Out of Louisiana.
Yes, Judge.
They come to Houston.
Yes.
All 4 of them.
Yes.
How do we know the other ones knew that it was stolen? Do we have any kind of...
In Louisiana, and they did it in real time. And the complainant stated none of the occupants in the vehicle had permission to take the vehicle.
I know that.
Oh,
But how do we know that they knew that it was stolen, right? So what if I come pick you up in my car?
Oh,
It's
I
a
see
stolen
what you're
car.
saying.
You have
So-
no idea it's stolen.
I see.
Like if everything's ripped off in the inside, you got like, you know, there's a screwdriver for the steering wheel and the steering column's been ripped off, then there's facts that lead you to believe that it's a stolen car.
So for running the plate because it was reported stolen and the fact that it was, well, at the time of the, I'm sorry?
That's still,
So again, on surveillance video in Louisiana, that they have it in Louisiana, that these are the original individuals that stole the vehicle. That's how they knew, that's how the officers in Paris and the officers in Louisiana knew that they knew it was stolen because they were the ones who stole it.
they have them, you saying on video?
Yes, that's what
All
I'm
four
trying to,
together is taken?
yes, that's what I'm
Yeah,
trying
well,
to.
that's something.
Can we see this video? I haven't seen this video. It's
You're
a,
not gonna get to see the video. That's what the
That's in
underlying criminal
Louisiana.
case.
well, you're basing your decision on a video that the prosecution that says he saw, you haven't seen, I haven't seen.
I just want to know how they impute the thievery to him.
Correct.
And he's saying that there's
it's
a
because of
video.
a surveillance video.
And the Louisiana officers were telling the Harris County deputies that they have it on surveillance video. That's how.
Specifically what? Where was my client? Was he the one?
We're not gonna get all that.
Right, but we're talking about that.
Criminal history?
No, Your Honor. This is based on flight risk. They literally transverse lines the same day they stole a car.
It hasn't been proven that he knew it was stolen.
How many got charged with the UUMV?
The driver, because that was
That's the only one.
driver, right?
So your position on bond is what?
There's no bond because of the flight risk. They literally fled the same day within 24 hours, really 24 hours within stealing a car. Judge. They literally fled the state.
They keep
stealing
saying
a car.
they stole the car. He didn't get charged with stealing the car. He's not in the vehicle. He is charged with transfer.
No.
He
He
is-
is charged
he is
in
being charged.
Louisiana.
Well, then that's a,
He is charged in Louisiana.
okay, well, he's
Here,
being charged with
he's being
that.
charged
Just
with
because
the-
he's charged with it doesn't mean you're going to convict him. I see like very good arguments as to why he shouldn't be convicted. Secondly, if we're talking about flight risk, he was a passenger. He hasn't had the opportunity. Where was he going? Did he know he was fleeing the jurisdiction? He doesn't know that it's stolen. Like you said, is the steering column broken? Okay, at that point, perfect. He should have known. There's nothing to say that that's what happened in this case. We're assuming the worst. Let's assume the best. He's presumed innocent. Let's not assume that he knew he was committing a crime. Let's presume he was innocent. So in that case, let's give him a bond. Let's allow him to go and fight this case. He can't fight it here. He's fighting an allegation that we don't have, the surveillance video that we haven't seen. Let him go fight the case over there. 21, sir.
I still stand on no bond.
I mean, I'm
Regarding the flight risk, and so
well, you got to understand, you know, in life, there are consequences to action, right? When you hang out with dogs, you get fleas. I can set you a bond, but you need to understand from the time that you're released, we give you 2 weeks from the date of that release to go turn yourself in to that parish in Louisiana. If you fail to do that, I will revoke the bond that I'm going to set here. I'll set it at 0. I will not give you another one. You can't run forever. At some point, we'll get you, and then that time, when we do get you, I will physically hold you until Louisiana comes and gets you. Do you understand?
So if I go down there, I'm at the bond down there 2 months.
That's correct.
Right. The thing is that I will probably set a bond around $5,000. You'll probably have to make all of it because you are a flight risk. You're wanted out of another state. If you waived yesterday, we have buses coming in and out of Louisiana about 2 times a week. So if you keep the waiver, you'll probably be back Wednesday. At the latest, Monday, you'll be back in Louisiana Monday-ish. Where if you want to bond out, you can, but you're going to have to make it on your own to Louisiana. And then you'll have to bond out. Or no, you're going to have to turn yourself in over there. You can't bond out. Is there no bond set?
I believe it's no bond. I'll double check.
You'll have to turn yourself in there. So if you want me to set a bond, you have to withdraw your waiver and you're going to lose the credit that you've built up toward them. Because if Louisiana doesn't come get you here within 14 days, we release you regardless. And then you don't pay anything. You're going to get released. So I'll let you talk with Ricardo and make the decision what you want to do.
Yes, sir.
What amount would you be thinking, Judge?
5,000.
5,000? Judge, he is 21 years old.
Yes, sir.
He would be seeking the support of his parents. It would be a bond that he's got to post 100% on. Would you consider going to 2,500? No? Okay, fair enough. I'll talk to my
You'd
client.
even get a bond, Mr. Calhoun, really. And I don't even know if I'm going to do the other ones as well, you know? I mean, I don't know.
I'll
So,
talk to my client, Judge. Thank
Okay.
you. Appreciate it.
All right. Let's unpack what just happened here because this Louisiana stolen vehicle case is fascinating from a legal standpoint. You got 4 young men, including 2 under 21, caught in a stolen car that crossed state lines with firearm found inside. The prosecution is pushing for NO bond, arguing they're all flight risks because they literally fled Louisiana the same day the car was stolen. But, and this is the key, the defense attorney raises an excellent point. Just because you're a passenger in a stolen car doesn't mean you knew it was stolen. The judge even asked, what if I pick you up in my car and you have no idea it's stolen? That's the presumption of innocence at work. The judge ultimately offers a $5,000 bond, which he has to pay in full because of the flight risk, no bail bondsman discount. The judge's warning? When you hang out with dogs, you get fleas. In other words, your friend's bad choices can destroy your life. That's a lesson every young person needs to hear.
I'll just read you the PC summary again. So on March 23rd, 2025, in Harris County, Texas, officer was dispatched to a servant's call and met with the complainant witness, stated that the defendant is her husband. The complainant witness stated that she told the defendant that she was going to move back to Arizona that day, and they got into an argument. The defendant then told the complainant witness to hit him in the face. The complainant witness then struck him in the face 3 times.
right.
The complainant witness then stated 10 minutes later, she went into the bedroom where the defendant then laid down on top of her, grabbing her wrists, causing pain.
That's 10 minutes
That's
later.
10 minutes later. Grabbing her wrist, causing pain. Complainant witness then got one arm loose, grabbed the defendant's genitals, causing him to let go. And then the defendant then struck the complainant witness in the mouth, causing pain. And the officer observed the complainant witness to have bruises on her arms and injuries to her top and bottom leg.
How is it?
I think we are omitting some things that's pertinent to the decision that you're gonna make.
What?
She asked, she or her daughter told her that, you have to make a choice between,
Oh, that's right. Yeah. I remember. And then she makes a choice of him.
and she said, I'm leaving you and I'm going to be with my daughter and grandchild. And then he comes and tell her, if you're really that mad at me, then hit me. And that's when she went to him and hit him twice. Boom, boom.
How is it fair that I find probable cause on him and not on her? Why didn't they charge her?
So I would say one is the fact that he quite literally says to hit her, or to hit him.
Can't consent
Well, but that's, I mean-
to an offense, Judge. If he
can't
tells me
consent
to
to an
shoot
assault.
me,
Yeah, no. I mean, you can, like,
Yeah.
boxers consent to
You can
assault,
consent to
right?
assault. That's.
But, I mean, in this,
I think where we are for PC purposes, as far as this offense goes, is that it occurs 10 minutes later. Then we have essentially in a situation where he can't essentially claim self-defense if he's the one being the aggressor first, where he's grabbing her 10 minutes after this kind of initial incident happened. He's grabbing her, then she grabs his genitals, and then he punches her in the face. I think that's where we're at as far as PC goes.
I don't think that's the law, Judge. I don't think you can avoid what had happened earlier just because it was 10 minutes later. I don't think you can take the fact away that she was the one that instigated and was the culprit of the initial assault.
but there's a long cooling down period. You know, if it's like maybe a minute or two after the fact.
I would say.
And then, but nevertheless, though, how's it
Still
fair that she's
assaulted.
not charged? I mean, why does she get the benefit of the doubt? Because she's wearing a skirt.
I mean, the code does say you can consent to an assault.
If you consent to, if you tell me to shoot you and I kill you, you don't think the cop's gonna get me for murder?
Well, you can't consent if there's serious bodily injury involved. You can't consent if there's no threat or actual serious
Come on,
bodily
Mr. Sullivan.
less than the serious.
I mean, an assault does occur in this case with him and her, but there's also another one that
Right.
occurs, you know, so.
I would argue, Judge, that at this point, with the charge that we have, that's going to be fact issues that I'm sure we're going to parse through moving forward, but I think that's.
And I think it'll work to the benefit, you know. So, Mr. Sullivan, I'm going to find that there are sufficient probable cause to go forward with your case. Don't have any contact with this person, please. The only thing I'm going to ask you to do is don't pick up any new cases, don't have contact, and don't be possessing weapons. I don't know why they didn't charge the other person. I don't understand, and I don't know. But be it as it may, just don't have contact with this person. I think that, you know, it's just could be like a rumbling volcano, and the last thing we want to do is we don't want anything more to erupt. We don't want further charges, and just, you know, and I think that, you know, they'll take it into account when you guys are talking about this case, but just stay away. That's all I'm asking you to do. Okay?
But Judge, with all due respect, I don't think it's too late to not to file charges against that person. I mean, I've seen cases where there are 5 charges.
That's not me. That's up to the DA's office and intake whether they.
Then I think the DA's office should take that in advisement to file charges against the person who was the actual initiator of the contact between these parties. If they do it all the time, I've seen cases where the district attorney filed cases 1 year later. When they know that there's evidence to substantiate the filing of a charge against somebody.
Who knows? Maybe it will. I don't know. Do you mind filing no contact, no weapons? I've given you a lawyer. All you'd have to do is just stay in contact with Mr. Dixon. He'll tell you if and when you have to come back to court. I'm going to waive your appearance so you don't have to waste your time coming to court. Just stay in contact with him and he'll tell you if and when you have to come back. Don't leave until you sign the bond conditions. Once you sign them, you're free to go.
I gotta put some money.
Go. Take your time. Just come back.
Okay, I will. Thank you, sir. Thank you.
Take care, sir.
Now, this case right here is exactly why domestic violence situations are so incredibly complex in the legal system. Let's break down what happened. The wife tells her husband she's leaving him for her daughter and grandchild. He says, "If you're really that mad, hit me." She does, twice. Then, 10 minutes later, he grabs her wrist in the bedroom. She grabs his genitals to break free, and he punches her in the mouth. The defense attorney is asking a valid question. Why is only charged when SHE to the first punches? The prosecution argues a 10-minute cooling off period resets the situation, meaning his actions became a new assault, not self-defense. But the defense pushes back hard, even asking if she's getting special treatment because she's wearing a skirt. The judge admits he doesn't understand why she wasn't charged either, but says that's up to the DA's office. Even the judge called the situation a rumbling volcano. Domestic cases like this are legal minefields. Do you think both parties should have been charged, or does a 10-minute gap change everything?
Greg, this gentleman with you.
He is co-defendant with the other one, Your Honor, if I may. I'll wait. So I heard everything y'all said. You want to go first before I start my spiel here?
Which co-defendant?
Oh, yeah. What's the last name?
This is Doty.
Doty?
This is Doty, D-O-T-Y.
So, Mr. Doty, you're wanted out of the state of Louisiana for a particular charge. I think it's like a theft or whatnot of a car. Your lawyer, are you asking for a bond? Your lawyer's asking me to set you a bond, but I don't know. I've never met you before. I don't know anything about you. The way I get to know you is how you look on paper, because that really tells me who you are, whether to grant you a bond or not. The good news for you is that if it doesn't happen, we have so many buses coming in and out of Louisiana into Harris County, because we have a lot of Louisiana people here, that I'd say might be once, at least once, if not twice a week, we have buses coming in and out of here, shuffling people to and from Louisiana. Mr. Kim.
Your Honor, same as the previous approach, is that this is one of 4 occupants of a vehicle that was stolen earlier that day in Louisiana, and they traversed the state lines, being apprehended in Harris County. State would be opposed to a bond due to flight risk of traversing state lines. The same day they stole the vehicle, felony out of Louisiana, where they were captured on surveillance video.
Any criminal history?
No, Your Honor.
If I may, Your Honor, he has no ties here. He lives in Natchitoches County, like a parish, I'm sorry. He worked, his address is 500 North Street, apartment, what did that say?
A4.
A4?
H.
H4, Louisiana, zip code 71457. He lives there with his mother, Cynthia. He, 2023, got his GED from a program there called Ben Johnson. He also works at Pilgrim's Pride, which is a chicken plant And so why are we holding him and paying him to pick him up? I would ask for general order bond, and he's going back to Louisiana. He's not staying here. That's where he lives. That's where he resides. And he can go post bond, get his lawyer, and deal with it. If he was charged with this in Harris County, this would be a criminal trespass. He's not the driver. The driver's charged in the 177th for unauthorized use of a motor vehicle. So if the appropriate charge in Harris County, if they had even been charged in Harris County, would have been a misdemeanor trespass.
I'm not going to give him a PR bond. I mean, he's a fugitive wanted from another state,
Well, he's an 18-year-old kid. I would ask if you would go lower than...
You need to understand, Mr. Doty, that actions have serious consequences. You're only 18. Are you 18? How old are you?
18.
You're just now starting your life. And when you hang with dogs, you get fleas. We have enough people in there now that become statistics, all they do is they end up running with the wrong crowd, end up with convictions, and essentially ruining their life. Once you become a convicted felon, it becomes extremely difficult to get a job, to get any kind of position of trust. People don't trust convicted felons. You don't get a good job when you're a convicted felon because no one trusts you. They're always going to think in the back of mind, okay, is this guy going to steal from me? Is this guy going to do this to me? Is he going to... You're on the road fast with what's happening now. Your lawyer wants me to give you a very low or free bond, but I can't. You are wanted out of another state. You are an inherent flight risk. And the problem is, any bond I set here now, because of the nature of this case, you're going to have to pony up a majority, if not all, of the bond because you're wanted out of another state. The thing is if you don't have anyone to pony up that money, your mom is a single mother, she's probably working her butt just to make it survive. You think she has enough money to just pony up money to get you out? This is what you need to think about when you start running with the wrong crowd. Because if you ain't got anyone to pony up money to get you out, you're stuck like Chuck until whatever happens with you. And I'll tell you now, more people plead guilty just to get out than they should. Because no one's going to wait 5 months just to fight a case. I don't know what an appropriate amount is, Greg, but it has to be sufficiently high that he's going to go back.
But he's going to go back. Was he going to stay here? He doesn't.
How?
He doesn't have anyone here.
How's he going to get back?
Gets out, calls his mom, and his mom provides transportation.
Have you talked to mom to see if she...
I'm going to call mom. I was going to see what the bond was, see if she can get him out.
Call mom. I want to know if she's going to come here and pick him up, and then we'll talk.
Okay, thank you.
I don't want to set people up to fail, but if he's got no ride, if he doesn't have anyone, then...
Okay. Thank you.
Let me know, Greg. And hey, Greg, if she does, I'm willing to go a little bit lower.
Okay, I'll try to get a hold of her. Thank you. No.
That's fine.
Oh, good morning, Mr. Butler.
Good morning. How you doing, sir?
Your lawyer is asking for me to set you a PR bond, but you just picked up another case. Why are you looking at me all confused? You've got a long list of criminal history. You're on bond for a felony unauthorized use of a motor vehicle, and now you've picked up a theft. What happened in the theft, if you don't mind?
It is a retail theft, Your Honor.
Silly.
He was observed, surveillance video, placing merchandise in a black suitcase he obtained from the business and crossed all points of sale without attempting to pay. It was in Target, Your Honor.
The funny thing is that it would only cost $100 to get you out of jail. You now know you have no one in this life that would pony up $100 to get you. Why? You're just, why would we do this?
I was getting close. I had to. Okay.
I don't want you to talk about the case, but Mr. Butler, with all your criminal history, who do you live with?
I live by myself, but somebody is like living there, so I can't even get inside the place while they good. So every time I go through...
I'm not giving you a PR bond so you can just go roam the streets. If he has, like,
I have an address.
some familial place, like a mop, or, uncle, aunt, I'd consider, I'm not letting you out just for you to go roam the streets and up to no more good. No, that's not what we're doing. So if you can figure out something, he's got some family or somewhere where he can go, and I know he's got a bed to stay at, then let's talk. But until that point, no, not to the street. Nothing good happens on the streets. And if I let you out, I'm going to have you come testing all the time because I don't want you using anything. Do you understand?
Sure.
Okay, so figure it out and then let's talk, but not to the street.
All right, appreciate it. Thank you.
Yeah. Do you have the?
Am I approaching?
I haven't, Judge. No, we're waiting for.
I'm ready when you are.
For my guy? Oh, they got
You can bring him out next.
Okay.
Good morning, Mr. Living.
How you doing?
Oh my goodness. You were wanted out of the state of Nevada for, number 1, robbery with use of a deadly weapon or tear gas, ×2. Burglary while in possession of a firearm or a deadly weapon, ×2 counts. 3, kidnapping, first degree with the use of a deadly weapon or tear gas, ×2. Number 4, conspiracy to commit kidnapping, first degree, ×2 counts. And 5, conspiracy to commit robbery, ×2 counts. Are you waiving formal extradition, sir?
Are you waiving the proceedings that we talked about? You want the 14 days? Yes, Judge, he's waiving.
Okay, good luck, sir.
Thank you, Judge. Does he need to sign it all?
He does. He needs to sign right there.
Okay.
If you need a pen, I got one.
I got one, Judge.
That was Living. Living, I'm not done with you. You doing Civil War? You want some? Get moving. Okay, thanks,
Thank you.
Ricardo.
Appreciate it. What's that call about the dirt guy? Okay, cool. What happened?
Lamar Mesa. Is discovery complete on this case? State.
There was surveillance video that we just put that, it's not gonna see. And screen, body one camera, dash camera, and surveillance video, I can prove that.
Please get on it. This case is 1,256 days old. If you ever take off on me again, I'm gonna make your bond so high, you're gonna have teeth falling out. Do you understand? As of today, you will get an ankle monitor, so I know where you are at all times. I'm giving you 30 days from today to make a decision on what to do in this case. We will either set you for trial, or you must accept the plea bargain from the state in 30 days. And like I said, you ever take off on me again, your bond will reach the clouds. Do you understand? Where is this then? Is this a co-defendant of the other one? I mean, are they the same day for real? Remember the one we had earlier today? Ms. Okafor.
Greg.
Oh.
Greg.
What was that? Defendant, what was that one? Nieves, was that?
1269.
Oh, this one, it's not a codefendant.
Ah. So where's this one from? Is this Target? Is this?
This is from J.C. Penney.
I'm ordering you as a condition of your bond not to go to any J.C. Penney for any reason. Do not pick up a new case. And I'm going to tell you now, Mr. Lamar Mesa, I'm going to do everything in my power to protect my community at all costs. If I find that you're a danger to my community, I only have one place for you. Okay?
All right, 30 days?
30 days.
Okay, thank you.
Do not leave until you sign our bond conditions. Don't worry about filing it because I'm having it monitored, so we can do it with Lisa. All right.
Client told me that he has a VAWA case pending,
It's a what?
VAWA case pending in immigration process.
Okay.
So we have an offer. I asked, are you ready to plea or not? He's kind of like iffy about it because he doesn't know how that's going to affect.
We need to.
Can we get a short recess just so he can get an appointment with his immigration attorney and see if, we don't have a lot of options. It says plea or trial at this point.
And I'm going to tell you now, I'm a time served on a second. Yeah, just so you know.
I
Okay.
told him because at probation, ICE might pick him up in one of his check-ins and time serve is ideal for him in his situation, but I think that we can just get his dismissal left and
Yeah,
right.
we don't, so, okay, I'll give you a week.
Yeah,
Okay.
and I'm gonna tell him just check in with the immigration attorney by next week, and if not, I mean,
So-
trial, I mean, that's pretty much it.
We're-
Senor Ramirez? He's a Spanish speaker judge.
So do I.
Oh, yeah, I forgot about that.
Tu caso ya tiene 200 días. Es tiempo para tomar una oferta o poner tu caso en jurado con juicio. Tú tienes una semana para hablar con un abogado de inmigración. Yo no te doy más tiempo después de una semana. ¿Me entiendes? Si no lo tienes hecho, no me importa. Vamos a ir adelante. ¿Entiendes? Ok, una semana.
Okay, all right. Ahorita hablamos.
And that, ladies and gentlemen, wraps up another absolutely jam-packed day in courtroom. Let's recap what we witnessed today. First, we saw a woman already on bond for a felony get a stern warning from the judge about driving without a license, with a threat of 6 months in jail for every violation. The message was crystal clear. Follow the rules or face the consequences. Then we had a theft case that dragged on for over 1,269 days. That's nearly 3.5 years. All because the defendant didn't show up to court. She now has an ankle monitor and 2 weeks to complete an anti-theft class, or she's going to trial. We witnessed a DWI defendant take a plea deal against his attorney's advice, choosing 21 days in jail over waiting months to potentially fight the case. This highlighted a harsh reality of our justice system. Many people plead guilty just to get out of custody, not because they're actually guilty. The Louisiana stolen vehicle case gave us incredible legal drama. For young men, a stolen car, state lines crossed, a concealed firearm, and a fierce debate about whether passengers can be held responsible for crimes they may not have known about. The judge's wisdom? When you hang out with dogs, you get fleas. And finally, the domestic assault case showed us the messy gray areas of the law, where cooling off periods, consent to assault, and questions about who really started the fight left even the judge scratching his head about why only one party was charged. If you found these cases as shocking and thought-provoking as we did, make sure to smash that like button. Drop your opinions in the comments below. We want to hear your takes on these cases. And if you haven't already, hit that subscribe button and turn on notifications so you never miss another jaw-dropping courtroom breakdown. Share this video with someone who needs to see how the justice system really works. Thanks for watching, and we'll see you in the next one.